So today I am going to talk about the 5 most common questions that you should be asking when you are starting your business. Now, there are definitely more than 5 questions. I usually get, as a business attorney, many, but these are 5 really good questions to be asking when you are starting your business. Now, even if you already have a continuing business, you might want to still figure out, hey, do these 5 questions apply to me? Will they still help me? And often for my clients who already have their businesses, these questions are still applicable. So before I get started, my name is Tania Shah, and I am a business attorney and co-founder of In the Know Legal. So what are 5 legal questions that every startup should ask? Now, remember, I am an attorney, but I am not your attorney. And since the laws differ in every state, these would be great questions to ask your attorney in your particular state. So the first question that we would ask is, what is the proper form of organization for my business? Should I be an LLC? Should I be an S corporation? Should I be a C corporation? Should I be a not-for-profit? Should I be a sole proprietor? Now, in one of our segments about choosing your business entity, we cover the differences between those entities so that you can have a better idea of how they might serve your business. The second question is, what do I do about employees or independent contractors, and how do I choose? Well, this is absolutely a state-by-state issue. I happen to live in 2 states that have the strictest laws when they come to independent contractors, and that is California and Massachusetts. So I'm going to tell you what the possible strictest requirements are for independent contractors, but remember, your state may have different standards. In these 2 states, you cannot be an independent contractor if you do what the business does. So for example, if I hire a tutor for my tutoring business, no matter how infrequent that tutor may tutor for my tutoring business, once a month, here and there, they set their own hours, they need to be they need to be an employee if I am hiring them from California or Massachusetts, because they do what my business does. Otherwise, the 2 other requirements are pretty common, which are freedom from control and their ability to engage in other employment and things like that. So those usually aren't the most difficult standards. The difficult standard in those states, such as Massachusetts and California, that have a stricter independent contractor law, most people who will work are classified as employees. So that is just an example where if you are deciding between hiring an employee or an independent contractor, make sure you check the laws of your state on what actually qualifies as an independent contractor. Okay. The next question is, how do we raise money without giving away a lot of our business? Well, as you know, a lot of times when you raise money, you have investors, and in exchange, they'll get a piece of the pie. Well, one way to do that is to simply have business loans, whether that is with friends and families who have loans or with a bank. So that way, you are not actually giving away parts of your company to investors. Number 4, how do we protect our intellectual property that is not covered by copyright, trademark, or patent law? So when people think of intellectual property, they think, oh, I need to trademark something, or I need to make sure I get this copyrighted or patented. But there's a lot of other things, right, that have to do with things that you've created that are not necessarily protected by those laws. So it's really nice to have what we call a confidentiality clause saying, know-how, your ideas, your systems, things like that, those are all protected. And there is a duty for the other party, whether they be an employee, a vendor, a partner, to hold that information confidential. And then number 5, when and how should I bring in partners? Well, the term partner these days are not always used in its strictest sense. This kind of goes back to something I talked about earlier in number 3, which is giving away parts of your company. In a true sense, if you make somebody part of your company as a partner, as a shareholder, they have ownership interests, but you don't have to do that. In fact, you can keep all of your ownership interests, but still make somebody a very key part of your company by maybe giving them a profit sharing interest or decision-making interest, right? That does not mean that they have an ownership interest in your company, but there are other ways that you can show these so-called partners that you really appreciate the work that they're doing and that they're important and that they have some stake in the outcome and the success of the company. And again, that could be by a profit sharing interest or a voting interest that has nothing to do with ownership. Well, thank you very much for joining me for 5 legal questions every startup should ask.